All right, you may begin. I assume, Mr. Erbe, you're going to go, you are the resistor. Oh, no, excuse me. No, it'd be Mr. Hinchliff first. Sorry, I have my notes mixed up.
May I proceed, Your Honor? May it please the court, counsel. Mr. Schindler and I represent Charles Gabus Ford, Inc. in this matter. The facts of this case are very clear, I believe. One, a valid test was conducted on Mr. Woods. Two, Mr. Woods tested positive for methamphetamine in his system. Three, during the testing procedure, there were actually 2 tests conducted because the first test contained adulterated urine. 4, the second test that was provided indicated a positive result. And finally, Mr. Woods was provided notice of that test result. Now, in terms of what we're requesting that the court do, this court should reverse the decision of the Court of Appeals on the issue of notice, in which we believe the district court correctly found that Charles Gabus Ford, Inc. substantially complied with essential matters necessary to assure the reasonable objectives of Iowa Code Section 730.5 regarding the random drug testing of Lucas Woods. Now, in terms of the notice requirement, the Sims case specifically identifies that substantial compliance is said to be compliance in respect to essential matters necessary to assure the reasonable objectives of the statute. The objective of the statute, at least...
Counsel, what are we to make of all of the musts and the shalls in that statute? Doesn't that command a very specific thing?
Yes, Your Honor. I believe, and I believe this was referenced within the Court of Appeals ruling, that shall connotates a duty in terms of Iowa Code Section 4.1 sub 30. But taking that into account together with the Sims decision that was specifically found, or that specifically indicated the notice provision and substantial compliance with the notice provision, the actual notice that was provided to Mr. Woods in this case, which I believe was Exhibit Q from the trial record, identified each requirement for purposes of the notice except for the cost of the test. And in terms of the except for the cost of the test, it is not, in terms of substantial compliance, at least comparing the language of fulfilling the obligation of substantial compliance and contrasting that against a more strict compliance standard, if the only piece of the notice that's missing is the cost of the test, and the court requires that the cost of the test be indicated within the notice, then that is tantamount to strict compliance.
Counsel, do you agree here that this notice did not strictly comply with the statute?
Due to the language of the statute, it does say that the employer shall include the cost of the test. However, the governing case law in terms of Sims on this issue identifies that the legislature's intent was to ensure the accuracy of any drug test serving as the basis for adverse employment action.
Counsel, if you admit that the notice did not include that cost amount, how can that be substantial compliance?
Your Honor, in terms of identifying the essential matters necessary to assure the reasonable objectives of the statute, I believe the procedure that's associated with the testing itself it is in an effort to ensure accuracy. And the facts
Well,
of this.
but the legislature expressly put in the notices to include cost of testing. If you'd said in the notice that it was about $100 and it turned out to be $125, that might be substantial compliance. But as to the element that the legislature put in the statute, namely cost of compliance, there is nothing. Isn't that a problem?
Your Honor, I think in terms of addressing the specific facts of this case, in terms of how the testing regime went forward, I do not believe it's a problem. And the reason is this. Mr. Woods indicated that during the testing procedure that he would test positive for methamphetamine. He indicated that to Brandon Carter, who is the third-party urinalysis administrator. And during that test, there was also it was a two-phased test that occurred on August 9th, 2017, where the first test, not only did Mr. Woods not produce enough urine, enough amount, it was also the wrong color, and it was the wrong temperature. So he had to go back out into the lobby, drink more water, and come back. And as soon as the proper amount was produced in terms of forming the test, he was able to indicate to the testing administrator that he was going to test positive. So in terms of...
So why do you need to do anything after that point? If that's substantial compliance based on what he said, why couldn't you just fire him then, and why even proceed?
Your Honor, in terms of the action that was taken by the employer was as a result of the test.
But my point is that the notice requirements are there for a reason, and the fact that someone who later denied that he said those things admitted that he was going to test positive doesn't really go to the employer's obligation then to provide the notice as required by the statute.
Your Honor, in terms of the notice itself, it identifies that if the split sample in the second confirmatory test that would occur if the employee requested it, that would be the cost of Charles Gabus Ford if, in fact, the test result came back negative. And at the time of the test, Mr. Woods knew that he was going to test positive. And after the test, when the notice was sent, Mr. Woods knew that that result was going to be positive. And I believe the district court indicated in their ruling that Mr. Woods sat on his rights and didn't have a retest, didn't go out to another third party and have another test to disconfirm or to negate that.
I want to make sure I've got the facts right. Did Mr. Woods make those comments, whether he acknowledges them or not, the comments you've just talked about, did he make those comments after the testing procedure had launched? Whether or not it was completed or not, I mean, there had already been the cattle call for people to be tested. Am I correct that those statements were made in response to the launching of a test? They weren't just made one day at work without being prompted.
Those statements were made in between. It was either during the first part of the test or the second part of the test to Brandon Carter, where Brandon Carter was the administrator at Mid-Iowa Occupational Testing, that during that process of providing a sample, and Brandon Carter specifically stated that he couldn't remember whether it was in between the commencement of the first test or the second test that the admission was made to him.
Isn't the cost of the test important to someone deciding whether to fund a retest out of their own pocket?
Yes, Your Honor, if they believe that the testing procedures were either invalid or improperly done or otherwise.
But if we say it's substantial compliance if the notice included everything else but omitted the cost of the retest, haven't we effectively written out that requirement the legislature imposed? Tell them the cost of the test.
Under the facts of this case, Your Honor, I don't think so. I think if it were universally applied, perhaps, but under the facts of this case, Mr. Woods indicated during the test itself that he believed he would be positive for methamphetamine, or that he would be positive for methamphetamine.
Is that later, or he denied it later, right? So the fact question over that, did the district court make a finding that he said that?
Yes, Your Honor.
Okay, and that finding's binding on us, since it's supported by substantial evidence, the testimony of the person who heard it?
I believe so, Your Honor, yes.
Okay.
Argument goes a little bit more, sorry. Your argument goes more maybe to the remedy or whether or not Mr. Woods was aggrieved, as opposed to whether or not Charles Gabus actually complied with the statute. But could you talk about the remedy? If we agree with the Court of Appeals, could you talk about what kind of remedy you think is appropriate? Or if we even need to address that, or should we just leave that to the district court?
Your Honor, I believe that issue should be left to the district court. We would assert that Charles Gabus Ford did substantially comply with the notice requirement under the statute. But if the court was to address a remedy here, I believe that would be best left to the district court. In terms of the function of the statute, I believe that the employer and employee relationship includes the obligation for the employer to comply with the statute, but the case law that identifies how the employer can comply with the statute indicates that the substantial compliance with the notice requirement will suffice. In the Sims case, the conclusion was based on oral notice provided to the employee at the time, and then the 6 months later provided written notice of the failed test. And the oral notice at the time didn't serve to adequately protect the employee from the consequences of a potentially erroneous test result. Here, we don't have a potentially erroneous test result, and we have written notice.
I mean, I don't know. I guess maybe I'm beating a dead horse. In fact, I'm sure I'm beating a dead horse. But if the cost of the retest, if you're Lucas Woods and you believe in your mind, you know, I've been using and I probably legitimately tested positive. It's probably a correct result. But the cost of the retest is $10. You might say, well, gee, it's worth $10 to see if I can keep my job. If the cost of the retest is $1,000, it probably wouldn't be. So isn't that something that could be material to the employee and is therefore something that should be disclosed as substantial compliance?
In terms of the way that the sample was collected, so the two vials that the sample was poured into and that Mr. Woods signed the CCF form that indicated that, you know, these two samples were taken at that time, the one vial was used to test and to be sent to a lab for verification and then sent to a medical review officer. But the second vial, which was from the same sample, Mr. Woods knew that that would come back negative, or excuse me, positive. So the non-negative test result at the time of the testing and Mr. Woods' indication that during the testing that he was going to test positive, a second confirmatory test of the second sample would not change the result.
Here's what Mr. Woods testified to. And again, I'm making no judgment about the actual facts of the case other than, you know, the record is the record. I don't really I'm just exploring the legal issue, which is what we're doing here. If you had known how much a retest would cost, would you have requested one? That's, I guess, what Mr. Erbe asked him. He says, I suppose it depended on how much it was. Question, why would you want to have a retest done? Answer, I mean, since I didn't have a job anymore, if it was, cheap enough, I probably would have, just for the sake of, I wanted to work. I wanted the job. That seems like, pretty, credible testimony, doesn't it?
In terms of the testimony that's made on that, his obligation or his opportunity to do a second confirmatory test and his knowledge of the sample that was collected at the time, Mr. Woods would know and did know that it would come back positive for methamphetamine. In terms,
Your time is up if you'd like to wrap up quick.
Yes, Your Honor. We would ask that the court reverse the decision of the Court of Appeals and affirm the district court's dismissal of Mr. Woods' petition and the conclusion that Charles Gabus Ford substantially complied with Iowa Code Section 730.5. Thank you.
Thank you. And Mr. Erbe, when you're ready.
Mr. Woods did not know that he would test positive.
Well, we're reviewing the fact findings and conclusions from a bench trial. Did the district court make a finding that he did admit to using meth?
She did, Your Honor.
Okay. Are we bound by that finding?
If it's supported by substantial evidence, Your Honor, yes.
And what's the legal effect of that? Does that mean he's not an aggrieved party? Because even if he had been told the cost and he would have either said, why bother with the retest? It'll just prove me again, that I was positive, or he'd skip the test, or if he took it, it'd be positive again. He loses either way. Are you stuck?
I don't agree with that, Judge, because he's an aggrieved party due to the fact that he never took the retest. He did not take the retest because the notice did not tell him how much the test would cost. Now, as the Court of Appeals noted, that leaves us in a vacuum of information about what would happen if there had been a second test. And I agree with counsel, actually, that this issue wasn't reached by the district court, and it might not be the time to respectfully address it now. But certainly back at the district court, Your Honor, our position would be that any vacuum of information about the second test and what those results would have been, the consequences of that vacuum of information should fall on the defendant, which caused the vacuum of information by failing to include the cost of the retest in the post-test notice. We would argue in the district court that Mr. Woods should not be punished by finding him to be not an aggrieved party and be precluded from any recovery in this case because of an error made by the defendant.
Following up on a question Justice Appel asked your opposing counsel, should we look at substantial compliance not on the notice as a whole, but on each item it was supposed to include? So it's supposed to include the cost of a retest, and it's silent, no substantial compliance, right?
I agree, Judge, that the notice needs to be reviewed per each requirement that is supposed to be in the notice. Now, as I understand the defendant's argument, it's stating that the notice and the overall compliance with the 730.5 provisions is to be analyzed as a whole. I believe that's a quote from the defendant's briefing. But that's a difficult standard to apply because that's not how the courts have reviewed substantial compliance. It's always looked at individual sections in 730.5, even sentences or individual paragraphs. For example, in the McVeigh v. tow truck case, the issue there was whether or not the policy was provided to the employee and whether there was a fact question on that. It did not matter in that case whether the employer had complied with 99% of the rest of the statute. This court reversed and remanded and found a fact question simply because there was a factual dispute over whether the policy had been provided to the employee. So I do believe, Your Honors, that the statute needs to be read in each discrete requirement, and substantial compliance has to be viewed per each requirement, which is actually what this court did in the Harrison v. Employment Appeal Board decision. Now, that was, of course, an appeal from an unemployment benefits decision, Iowa Workforce Development, the Employment Appeal Board.
Mr. Erbe, if we agree with you on that point and we were to affirm the Court of Appeals finding no substantial compliance, can you discuss the issue of what remedies would be available in the district court and also the damages that might be available? And as I read Sims, maybe there would not be an opportunity for damages because here I think we have a positive test and at least on the findings that are made, probably accurate in terms of the result. So can you address those two issues for me?
Yeah. I respectfully disagree, Your Honor. First, to the extent we have a positive test here, that was only the initial test. We don't know, and we will never know, what the retest of the split sample would have come back as. So certainly there was an initial positive test, but that's not really the question here because an employer can only take minor disciplinary action, suspension perhaps, based upon that initial test and an initial positive test. It cannot terminate an employee like Mr. Woods here unless there's a confirmed positive and then the chance for the retest. Basically, you need to have 3 tests. And we never got to that 3rd test here, Judge. We didn't get to that 3rd test because Mr. Woods chose not to take it because he wasn't sure how much the retest would cost due to the notice's deficiencies. But more importantly, Your Honor, the distinguishing feature between this case and Sims, in Sims, that employee actually had the retest, had that 3rd test. The very test that Mr. Woods did not have in this case. And that separates Sims from the case before the court right now. In Sims, that party was not aggrieved because, in essence, the court almost looked at it as a causation standpoint. The test eventually, albeit in a very tardy manner, came back and confirmed the 2 previous positive tests. And it's almost as if the court in Sims took a no harm, no foul approach. In the end, so the test was very late, and maybe that wasn't substantial compliance with 730.5, but it did not matter because apparently no matter when that employee had the retest done, whether it was 6 days, 6 weeks, 6 months, however long, it would have come back as a 3rd positive test. The employee would have been fired, and therefore the court decided, really from a causation standpoint, not an aggrieved party, no damages, perhaps attorney fees and expenses. But here we don't have that 3rd test, Your Honors. And that's what distinguishes Sims from the instant case.
Counsel, can you just confirm, did the 2nd test get done? Is it only the 3rd retest that didn't get done?
Yes, Your Honor.
Okay, I thought I heard you differently earlier. Thank you.
Okay.
Well, we're a court of review, not first view, so should we, if you win this stage, do we just wait for the district court on remand to decide the remedies? You don't want us to opine on what they would be?
That's correct, Your Honor. Respectfully, we never really had a chance to argue that with the district court because the district court ended it at no violation. And I believe that the party should first argue this to the district court, get a decision from the district court, and then have further appeals if necessary after that, Your Honor. In the end, after all of this discussion, this case boils down to one fact. The defendant did not include the cost of retesting in his post-test notice. And that was required by the plain language of 730.5, which states that the employer is supposed to tell the employee what the fee payable is to the employer, for the cost of any retesting. And that's clear as a bell. And to the extent that that plain statutory language isn't clear, this court in the Harrison decision in 2003 interpreted that language to mean that the employer has to tell the employee, quote, or close to a quote, what the cost of the test will be. And that was completely omitted. And as Justice Appel noted, we're not talking here about a ticky-tack violation where the employer was off by a couple bucks or missed a decimal point or a dollar sign or anything like that. This was a complete omission of a statutorily required piece
Wouldn't
of
a
information.
complete omission be not even any reference at all that he has to pay the cost, period? Wouldn't that be even a more complete omission? It's my understanding that a reference was made that he'd have to pay costs, just not an amount. Isn't that correct?
I believe, Judge, the notice simply stated that any fee would be reimbursed if there was not a confirmed positive test.
Maybe I'm looking at the wrong document. But I'm looking at the letter saying that one test came back, confirmatory, of your choice at your own cost.
Correct, Your Honor.
So at least puts the ball back in his court that he's on notice that he'll have to pay for it. We just didn't talk money. Wouldn't that be even more of a blatant omission to not even mention that they have to pay for it?
Which would be a more blatant omission, Your Honor. I apologize.
Well, you mentioned that what the Justice Appel's example was a clear-cut omission, and I thought, well, I think it could be even worse. It could be worse if he wasn't informed that he had to pay the cost, period. I don't know if I'm making myself clear, but the notice I'm looking at tells your client the opportunity to request and obtain a confirmatory test of the second sample collected of your choice at your own cost.
Correct, Your
Isn't
Honor.
that the document we're talking about?
It is, Your Honor.
Okay, so he was on notice that he'd have to pay it.
Right.
It's the dollar amount that's missing, but not referenced that he has to pay it.
Right.
Okay.
The missing amount, the missing is the cost of the test or the fee payable, referencing this court's Harrison decision and the notice provisions of 730.5.
Out of curiosity, what was the cost? Do we know?
No, Your Honor. It was never really established at trial what the cost would be, but I don't respectfully, I think that wouldn't matter because it's hindsight now. And
Counsel, let me ask this. If the cost really was the issue driving this, why didn't your client reach out and say, well, I might do this, what's it cost? Why didn't he do that? Why did he sit on his hands?
he testified that he did try to reach management at Charles Gabus Ford. Now, the district court rejected his testimony on that point, Your Honor, but he did testify that he attempted to make a call.
And that finding is one that we're stuck with at this phase?
I think, again, as Justice Waterman and I were discussing, it would be really a substantial evidence question, and there was disputed testimony. It was basically Mr. Woods' word against one of the Charles Gabus employees. He said he called, she said that she never got a call.
And the district court made a credibility determination, as it typically does, and found in favor of the other party here. So would you agree that it's an issue that if we find that the district court was right in making the credibility call, that we have to find that he didn't do anything?
From a substantial evidence point, yes, Your Honor. But though, would that be relevant necessarily? Because the notice that is supposed to go to Mr. Woods is set out in 730.5, and it's supposed to be a written notice sent by certified mail, and 730.5's notice provisions specify precisely what's to be in there, probably to avoid this exact issue, which is an ad hoc, did somebody call, did they not? What questions did they ask? Was the call ever returned? Did they send an email? Did they stop in? To avoid all of that and to avoid this ad hoc situation, as the defendant said, under the facts of this case, maybe there's substantial compliance even though there wouldn't be elsewhere. But that's not how the statute reads, though. But in the end, those sorts of things. Did Mr. Woods call or not? Did he try to get more information? It's shifting the burden. It's shifting the onus in this case that is supposed to be on the employer under 730.5 to prove compliance in all respects and substantial compliance and those things. And it's shifting it to Mr. Woods to explain what he did or did not do in response to a clear statutory violation. I see my time is up, Your Honors. May I have a moment to conclude?
Yes, please wrap it up.
Your Honors, we ask that the court affirm the Court of Appeals and remand this case to the District Court for further proceedings based upon 730.5's plain language. To do otherwise, to follow the defendant's suggested course would be to erase part of 730.5's notice provision and in essence judicially rewrite the statute. Thank you.
Thank you. Mr. Hinchliff?
Thank you, Your Honor. I would like to revisit something that Justice Waterman asked. If the court finds that the admission of the cost or the omission of the cost is substantial compliance, aren't we writing out the cost? In this case, no. The Exhibit Q, and I believe that's Appendix number 1, page 167, specifically identifies that if Mr. Woods retests the second sample and he tests negative, then Gabus Ford pays for the cost. So we're not writing out the importance of the cost by the inadvertent or accidental omission of the cost in this notice, because Mr. Woods was put on notice that his second sample could be retested, and if it came back negative, then Gabus Ford had to pay for it. So it wouldn't matter if the cost of the test was $10 or $1,000. If it was going to come back negative, then Gabus would pay for it. In terms of...
Yeah, but if he's doing a risk calculus, as Justice Mansfield suggested, maybe he might suspect it would come back positive. But for $1,000, the risk-benefit analysis doesn't work. But if it's $10, maybe he takes a chance and he takes the test to see what happens. And I apologize, Justice Mansfield, if I mischaracterized what you were asking earlier.
I think I was quoting from his testimony to that effect, kind of.
And I think that the district court made a finding as to what happened. At the time, it was either during the first adulterated sample test or the second test that came back positive, he made the admission. So in terms of having an opportunity or a meaningful opportunity to consider whether to take a confirmatory test, he had that at the time of the test. When the non-negative test occurred at the testing facility, and he indicated to the testing individual that he was going to come back positive, the eventual test result was inevitable. And the notice that was provided to him specifically indicates, if the results of the second test do not confirm the results of the initial confirmatory test, the employer shall reimburse the employee for the fee paid by the employee for the second test, and the initial confirmatory test shall not be considered positive test result for drugs for the purposes of taking disciplinary action. So he knew at the time he received the notice, which it was delivered on August 19, 2017, which was 10 days after the random drug test occurred. He knew at that time of the initial test, and he knew at the time of receiving the notice that it would be positive. And he also knew, as a result of the notice, that Gabus Ford would be obligated to pay for the cost of the test if he made the election to have the second sample tested. And, Your Honors, we would again request that the court reverse the decision of the Court of Appeals and affirm the district court's dismissal of Mr. Woods' petition. Thank you.
Thank you. The case of Woods versus Charles Gabus Ford is hereby submitted, and we will have a pause in the proceeding to allow the court to get ready for the next case, State versus Greg Davis.